Jennifer Quaid is an assistant professor in the civil law section at the University of Ottawa, specializing in corporate criminal liability. Thanks for coming to speak with me.
Thanks for having me.
Can you start by giving us a better idea of exactly what it is the federal court has decided today, why it has dismissed this application from SNC-Lavalin?
Well, essentially the actual proceeding was a motion on the part of the Public Prosecution Service to have the application struck. So it's a preemptive maneuver because it's saying we shouldn't even hear the application. There's no basis to hear the application. And the court agreed, and but rendered a 100-page decision to go with it, which all of us are eagerly going to read shortly. But based on the summary, there are a couple of things that are very clear. The first is that the state of the law, which every one of us who teaches criminal law was keen to see confirmed, is that prosecutorial discretion cannot be interfered with absent proof of an abuse, in which case there's only one remedy, that's a stay of proceedings, which means you put an end to whatever criminal proceeding is going on. So it's a very severe remedy, but it's also an extremely high bar to meet. That's the first thing. So they confirmed that that's the standard and there isn't a different standard. The second thing that they said is that the decisions that the Public Prosecution Service are called upon to make in the context of the remediation agreement regime, which was this new Part 22.1 added to the Criminal Code, those decisions are also prosecutorial discretion decisions, like other prosecutorial discretion decisions that prosecutors make all the time about how to conduct a criminal investigation, when to settle, etc. So this is not a different kind of decision, and therefore it does not invite a different kind of standard of review or any kind of limitation, because that was sort of the argument along the line, was to say, well, this is really kind of an administrative decision, and therefore there's scope for the federal court to come in and look at the legality of the decision. The court says absolutely not.
Right, so they've essentially said that there's nothing in the process here that gives you an out. The process is going the way it's supposed to go. This is the way it's supposed to unfold, and absent, as you say, any abuse of the process, you're going to face the trial, essentially. Well,
or potentially later on, there could be settlement discussions. But yes, there's not a possibility to attack directly, to put a full attack on the prosecutorial discretion. And it bears mentioning the court goes to the trouble of saying, we've considered the considerable amount of information that has been provided by the parties, and we've looked at the jurisprudence, we've looked at the rules, and we have come to the conclusion that there is no prospect that this application can succeed. Right. That's very strong language to say, I don't even need to go and hear you on the merits of this. It's so clear. So that, I think, is food for thought for those who've been trying to suggest that maybe the prosecution service didn't do such a good job. It clearly concluding that it isn't abusive is not the same as saying that that's the best decision one could have rendered, but it takes off the table the suggestion that the prosecution service was outside the scope of what they normally do.
Can you help us understand what might be at play here? And I'm not sure anybody knows the answer to this, but what's really been, I mean, it's been interesting to me to wonder, okay, you have the Prime Minister and his Principal Secretary and others pressing to have an outside opinion for Jody Wilson-Raybould, to get an outside opinion to look at remediation agreement, some kind of deferred prosecution agreement for SNC-Lavalin, and try to make that happen. And yet the former Attorney General's clearly not interested in intervening. The Director of Public Prosecutions is sticking by the process. Help us understand what it is they must know that says this is going to trial when you have the politicians saying, we got to look at a way to cut them a break here.
Well, that's a very relevant question. So the first thing is that we do not know all the facts, and there are a couple of things that I think maybe the general public doesn't realize. Remediation agreements are new, that's true. But we have other settlement mechanisms that exist that are similar, not the same, notably in competition offenses, so bid rigging, price fixing. Right. And so there is a kind of an understanding of how those processes work, and I'm fairly confident that the legal counsel who are advising SNC would have expected perhaps to have something similar happen. And in the context of those discussions, normally the company will try to sort of come forward, even if they've already been found out, they'll make an approach to sort of say, well, can we talk, and even though they haven't been formally invited yet. What we don't know, honestly, is what happened before September 4th. We know after September 4th, when the first decision is rendered and it says we're not going to invite you to negotiate.
Another
then
one, I think
there's
October
like
9th,
4 meetings, you know, 4 different communications, lots of lobbying. But I'm just talking as between the prosecutors and SNC-Lavalin, which are totally appropriate discussions, right? SNC says, look, have you looked at this information? You know, can we talk? And they do that 4 times, as well as, you know, providing lots of things to look at. And then the Public Prosecution Service comes out on October 9th and says, thank you for all that information. We've looked at it, but we are still not persuaded that this is in the public interest and appropriate in light of the legal criteria that are there, right? This is not just a random decision. It is a modulated
Right, and
determination.
discussions happen in a frame of what's allowable. Here's where you might qualify and here's where you don't.
But one of the things that we don't know is what exactly did SNC say. And I think that, you know, in the context of settlement discussions, they might provide confidential financial information that they're not willing to share with the public, perfectly reasonably, you know. And so I think the prosecutors would have had the best read on the information that was provided. Certainly, I would expect that the judge saw similar amounts of information. Maybe not all of it, but I would have expected most of it in order to make an assessment. But to me, a little understanding kind of the dynamics of what went on and what informed the decision, I'd like to know, was there actually information shared and communication before the 4th? Or were they really surprised? Because, you know, based on the experience in other cases, I said, like competition, they would have been surprised to receive a decision like that without having a chance to talk to them. And I could see why there would be this flurry afterwards.
For all us non-lawyers watching, you know, for a lot of us, the question comes down to, why do some politicians in the company think they need it so badly, this DPA, and why is the Director of Public Prosecution so determined not to let them have it? I mean, that's
that's the million-dollar question. We don't, and
we don't know that.
We don't know the reasons the public prosecution.
We'll have to see that. We'll have to see a court case. We'll have to, if it comes to that, that's where you find out.
Yes, you'll find out in some ways what the perspective of the prosecution service is on the case. Although you won't understand, they're not necessarily, and I would be very surprised that we would learn what the reasoning was behind the decision not to invite to negotiate in a direct way. We might be able to infer it from the arguments that are made, because all those discussions that are sort of in an effort to settle a case are covered by settlement privilege. So I don't expect SNC or the Public Prosecution Service to want to reveal more than is necessary out of what happened there, because those are failed negotiations, they're failed efforts, and we're very protective of that because we want parties to feel comfortable that they can settle things. But I mean, the question now is, you know, what's going to happen next?
Yes, and let's end on that. So it's now left to the new Attorney General, David Lametti, who could still offer them a remediation agreement for public. He could overrule essentially the Director of Public Prosecutions. Is that the way it works?
Yes, through this directive power. And it's never been done before where an Attorney General has decided to issue a directive in a specific prosecution involving a specific accused. So that's quite unusual. I mean, there have been directives issued, but more of a general nature, you know, with regard to certain types of litigation. Jody Wilson-Raybould did so with Aboriginal litigation. But to actually say in this particular case, where you as prosecutors have made a decision, I am going to issue a directive to say, I would like you to decide differently. And essentially, the only thing David Lametti can do, which was the only thing that Jody Wilson-Raybould could do, was to issue a directive to say, instead of refusing to invite them, you are going to invite them.
Right.
This is not the same thing as saying you can give them a deal.
Right. It means you have to at least give them a chance to make a case.
That's right. But the ultimate deal is subject to court approval. And I think people have lost sight of that Jody Wilson-Raybould was never in a position to say you should give them a deal. All she could say is you should offer to negotiate and see what you can do. Yeah.
All right. Lots to watch. Jennifer Quaid, thanks so much for your time. Appreciate it.
Thank you for having me.